said the grounds cited by the applicant for seeking custody orders can be summarized as hereunder. That the respondents are believed to be armed with sophisticated special weapons and are well trained and pose a threat to the country's security. That there is a need to intensify searches in places of residence associated with the respondents for materials of evidential value, and that the respondents have not fully disclosed their places of residence to the investigators, that it was considered urgent to pose the arrest of the respondents in order to prevent commission of crimes, that several investigations have not been concluded, that the respondents are likely to interfere with the opposite investigations and witnesses, and that the investigations relate to serious crimes which carry severe penalties upon conviction, and that it is desirable to have the respondents detained in custody to safeguard the integrity of investigations. In paragraph 4 of the supporting affidavit, dated 30th July 2025, number 237668, Chief Inspector Josephine Correll, it reports that on 28 July 2025, intelligence information was received to the effect that the respondents were planning to wage war against uniformed police officers and had formed a movement known as Fighting Brutality and Impunity, FPI, whose sole purpose is to recruit current and former police officers to allegedly fight illegal orders, which was considered by the applicant as a matter of serious national security concern. The respondents are said to have posted their intentions on their social media platforms with wide following. The first respondent is said to be operating an account under the handle at Osoi Patrick, while the second respondent operates an account under the handle at Cop Shakur, and the third respondent operates an account under the handle at Kimathi Hiram. All the respondents have been described as former members of the disciplined forces, with the third respondent being described as a police deserter who deserted duties at Chumfi Police Station on 21st July 2025. The applicant submits that the respondents are being investigated for offences ranging from preparation to commit a felony, possession of firearms and ammunition, incitement to mutiny, and recruitment and facilitation of terrorism acts. The applicant has annexed to this supporting affidavit social media posts and news reports allegedly capturing the activities of the respondents. In a post attributed to the first respondent with a timestamp of Monday, July 28, 2025, the first respondent is said to have made the following post, and I quote, "Having served as a KDF Special Forces soldier, NIS officer, and a US Army veteran, I have taken the solemn initiative of bringing together cops who share the same ideology of fighting for Kenyans by forming a movement dubbed Fighting Brutality and Impunity, FBI. Together with at Cop Shakur and at Kimathi Hiram, we present ourselves to fight for the rights of every Kenyan mistreated by the police who follow illegal orders. Victims of the June 25, 2024 and subsequent times. families of those killed during all these times, police officers and former police officers who have been neglected by the same system we fight for. Our mandate is to bring justice to our people, and we will fight tooth and nail to achieve it. End of quote. The applicant has also annexed a post attributable to the second respondent posted on Facebook, whose timestamp is not clear, in which the second respondent allegedly says he has teamed up with the first and third respondent to form FBI. A Facebook post attributable to the third respondent has also been annexed, in which the third respondent allegedly posted that he had teamed up with the first and second respondent to form FBI. It was submitted for the respondents that no evidence has been adduced to prove that the social media accounts belong to the respondents. But there are no element now that the respondents have formed a movement dubbed FBI. Article 33 of the Constitution provides for freedom of expression in the following terms. Articles 33(1). Every person has the right to freedom of expression, which includes a. Freedom to seek, receive, or impart information or ideas. Under Clause 2, it says the right to freedom of expression does not extend to propaganda for war, incitement to violence, hate speech, or advocacy of hatred that constitutes ethnic incitement, vilification of others, or incitement to cause harm, or is based on any grounds of discrimination specified under Article 27(4). And under Clause 3, it says, in the exercise of the right to freedom of expression, every person shall respect the rights and reputations of others. Article 36 provides for freedom of association, and I quote Article 36, Clause 1. Every person has the right to freedom of association, which includes the right to form, join, or participate in the activities of an association of any kind. And Article 24 provides for limitation of rights and fundamental freedoms. And I wish to revert to Articles 24(5), which provides as follows. Despite clauses 1 and 2, a provision in legislation may limit the application of the rights or fundamental freedoms in the following provision to persons serving in the Kenya Defence Forces or the National Police Service. And in Articles 31, that is on the right to privacy. Articles 36 on freedom of association. Articles 37 on freedom of assembly, demonstration, picketing, and petition. And Article 49 on rights of arrested persons. It is submitted that the respondents are either serving or former officers in the disciplined forces. The true status can only be established once investigations have been completed. A reading of Articles 36 and Article 24(5) shows that there are limitations to the freedom of association as relates to members of the disciplined forces. Article 33 on freedom of expression has limitations on matters related to promotion of propaganda for war, incitement to violence, hate speech, and advocacy of hatred. It is alleged that the respondents are well trained and may be in possession of sophisticated arms If this allegation is backed by uncontroverted evidence, it would amount to a compelling reason that militates against the grant of bond as provided for under Article 49 Clause 1H. Even if the respondents are current or former members of the discipline process, it is not unusual to see them in photographs depicting dressing in uniform and possession of firearms. This is more so when the photos are next have no timestamps. However, this is a matter which ought to be thoroughly investigated. Number 237668 to Inspector Josephine Korir has summarized matters pending investigations, which include cyber analysis and forensic exploitation of gadgets which have been recovered and others which are likely to be recovered. This court is now persuaded that these investigations would be hampered by the release of the respondents. The other ground cited for the detention of the respondents is to enable the applicant to conduct searches of premises associated with the respondents. The premises have not been stated. This is at best speculating. Even if it is believed that the respondents have residences which are yet to be established, I believe the applicant has adequate resources and capabilities to investigate where the premises are and to conduct contemplated searches. The fact that the premises have not been established diminishes the chances of recovery of evidential materials, even if the respondents are held in custody. What remains of concern to this court are the averments that the respondents might be in possession of firearms and ammunition. If that were the case, then the scenario would pose serious threats to national security. It would justify the denial of bond or of bail to each respondent. It is apparent that none of the respondents was found with firearms at the time of arrest. If any firearm or ammunition was recovered, it would oppose that the presumption that some other firearms and ammunition are yet to be recovered or are stashed away. Even if I were to believe that the respondents might be having firearms, it is the duty of investigative agencies to find the firearms and neutralize the security threat. It is submitted for the applicant that the respondent may interfere with witnesses and investigations. This court notes that the identities of potential witnesses have not been disclosed to the respondents. This fact alone limits the potential for witness interference. I do find that no evidence has been presented showing that any of the respondents has made contact with potential witnesses. Neither has any evidence been presented that the respondents have interfered with investigations. Concerns were raised that the respondents might remotely access their social media accounts. I note that the respondents were arrested between the 29th of July 2025 and 1st of August 2025. As such, the applicant has been in custody of each respondent for a minimum of 7 days. This is half the period sought by the applicant to hold the respondents in custody. The urgency associated with the investigations being undertaken by the applicant means that means that the applicant has covered substantial ground in the contemplated investigations, save for areas requiring this court's orders. Section 33 of Order Act number 30 of 2012 allows this court to conditionally release suspects unless let me repeat. Section 33 of OTA, Act number 30 of 2012 allows this court to conditionally release suspects under investigations in relation to investigations touching on alleged commission of terrorism offences. Section 36A of the Criminal Procedure Code also permits this court to conditionally release suspects while addressing concerns on integrity of pending investigations and prevention of acts of commission of offences while the suspects are out on bond. Having considered the entire circumstances of this matter, I do allow the consolidated application in terms of prayers 3 and 4, which is for searches and exploitation of electronic gadgets. And I do proceed to admit each respondent to bond of Kenya shillings 200,000, a surety of a similar amount, or cash bail of 50,000, and on the following conditions: that none of the respondents shall commit any offence while on release, that none of the respondents shall interfere with witnesses of the investigations in relation to the offences for which the respondents were arrested, or any offences being investigated, that each respondent shall avail himself before the applicant for purposes of facilitating the conduct of investigations once every week for such short a period as may be deemed appropriate by the investigators, and that each respondent shall avail himself in court as and when required and until this matter is finalized. That is the ruling.
Your Honor, thank you for the ruling. Your Honor, just need to bring to the attention of the court that Your Honor, the investigation